The Supreme Court strikes again. Let's play hardball. Good evening, I'm Joy Reid in New York, filling in for Chris Matthews. And leading off tonight, the Supreme Court's blow to affirmative action. In a case that could have implications for other states around the country, the court sided today with the state of Michigan, whose voters amended their constitution in 2006 to ban affirmative action. A lower court of appeals had overturned the state's action, saying the majority could not place unique burdens on minorities. But today, in a 6-2 decision with Justice Elena Kagan recusing herself, the Supreme Court disagreed. While not taking a position on the constitutionality of affirmative action itself, the court said states have a right to vote on whether or not to ban it. Justice Anthony Kennedy wrote for the majority, quote, "There is no authority in the Constitution of the United States or in this court's precedents for the judiciary to set aside Michigan laws that commit this policy determination to the voters. Deliberative debate on sensitive issues such as racial preferences all too often may shade into rancor, but that does not justify removing certain court-determined issues from the voters' reach. Democracy does not presume that some subjects are either too divisive or too profound for public debate." In other words, the majority of the citizens of Michigan should be able to decide whether or not affirmative action is right for their state. In addition to Michigan, 7 other states ban affirmative action, including California and Florida. Today's ruling could embolden more states to do the same. And for more on this heated case, I'm joined by Eugene Robinson, a columnist for The Washington Post and an MSNBC political analyst, and Horace Cooper, co-chairman of Project 21, the national leadership network of black conservatives. And Horace, I actually want to start with you on this decision. Why should a majority in a state who presumably are not minorities be able to decide, you know what, we no longer want to assist racial minorities who've suffered past discrimination? Why should they be able to do that?
Well, absolutely. The question is the framing problem. It's not the case that a decision was made to no longer help minorities. In fact, when the referendum ultimately passed, there were blacks, browns, whites, a number of people on both sides of the issue. And the court makes this clear. We can't assume for litigation purposes that a policy is pro-black or pro-white by assuming all parties in that group support or oppose. In this particular case, a community can decide that this technique is a divisive one that is not effective, and that they would rather pursue others. And I think that's what they did.
But Horace, the actual practical impact of that decision was that in Michigan, minority enrollment, black enrollment specifically, went down by 30%. So the practical impact of it was that minorities have less access to higher education in Michigan. You can't say to me that you think the majority of African Americans in Michigan assented to and affirmed that decision.
No, I didn't say that a majority did, but you also can't say that the minority of blacks who supported this policy shouldn't have the right to participate in the political process and make decisions.
Should they have a right to get into, I mean, if you have 30% less enrollment.
You shouldn't be able to say if black Americans are 15% of the population, that 6% of that 15% ought to be able to drive all of the public policy. And the court flatly rejected that, including Justice Breyer. The truth of the matter is the policy is looked upon skeptically by a majority of the population, and as Justice Breyer and the rest of that 6-2 majority made clear, there was no showing that the state of Michigan had been affirmatively going out of its way to engage in segregation or any form of discrimination. In fact, they had no plaintiffs that were saying, I tried to go to this school and I wasn't let in because of my race.
Let's go to you, Eugene Robinson. Is that the issue, that you need to be able to find someone to say that I myself was not let into school because of my race? I mean, the majority of people in southern states didn't want to have the Voting Rights Act imposed on them either, but we used to have a Supreme Court that looked out for that minority regardless.
Well, exactly. This is essentially a states' rights decision, or that's the way the court has framed it. This should be up to the states. Well, states' rights in the context of race in this country has a very specific meaning. I remember it from when I was growing up in South Carolina. States' rights meant we have the right to continue legal segregation in South Carolina. Now, that's not what we're talking about here in Michigan, but I think given Brown versus Board of Education, given the landmark civil rights legislation of the 60s, and frankly, given the long run of American history, there should be a special burden on states in regard to issues of race. And if you saw affirmative action, as I do, as a remedy that helps redress those many hundreds of years of American history, then I don't think the ruling is justified. I don't think the court was justified in saying Michigan can void that. But obviously this court disagrees.
Yeah, this is the majority on this court. Well, this case was it was obviously contentious, but it was also personal for some of the members of the bench. Justice Clarence Thomas has long opposed affirmative action. In the past, he's reflected on it personally. Back in 1982, he told the New York Times, quote, "I watched the operation of such affirmative action policies when I was in college, and I watched the destruction of many kids as a result." On the other side, Justice Sonia Sotomayor wrote a scathing dissent, which she actually read from the bench today. On the subject of race, she wrote, "The sentiment of some of her colleagues was out of touch with reality." Quote, "Race matters for reasons that really are only skin deep, that cannot be discussed any other way, and that cannot be wished away. Race matters to a young man's view of society when he spends his teenage years watching others tense up as he passes, no matter the neighborhood where he grew up. Race matters to a young woman's sense of self when she states her hometown and then is pressed, 'No, where are you really from?' regardless of how many generations her family has been in the country. Race matters because of the slights, the snickers, the silent judgments that reinforce that most crippling of thoughts, 'I do not belong here.' In my colleague's view, examining the racial impact of legislation only perpetuates racial discrimination. This refusal to accept the stark reality that race matters is regrettable." And Horace, I'll go to you because I note that Clarence Thomas made those observations about the destructive force of affirmative action from inside of a college where those students were attending, including at Yale. Horace?
Well, my organization actually put forward an amicus brief asking the court to not only take up this case, but to issue a ruling similar to the one that it did, precisely because we're trying to embark upon what Martin Luther King said 50 years ago, that we shouldn't let the race or skin color or even the chromosomal genotype, the gender of the individual, be the decisive factor in whether they get to go to school. Segregation as a policy actually sought to use gender and race as the talisman for whether people got to go to school. It was wrong then, it is wrong today. But it's important to understand the 6 people on this court agreed there was no claim that Michigan was engaging in a remedy. You have to have an identified violation in order for the remedy to be justified. Even Justice Breyer disagreed with that.
Horace, I have to ask you a question. Are you saying that Dr. Martin Luther King, when he was in Chicago fighting against housing discrimination, would have assented to the idea of letting Illinois voters vote on whether or not they preferred to keep housing anti-discrimination laws in housing, or that he would have preferred to let Mississippi voters vote on whether or not they wanted to have the Voting Rights Act?
We can try to pretend to opine about what Dr. Martin Luther King would have done or thought, but what he did say, and we don't have to opine about it, is that one day people would be looked upon not based on their color of their skin, but on the content of their character. Today's ruling moves us closer in that direction because there isn't any showing in the state of Michigan that, in fact, this remedy is a response to some past injustice. No such effort was put on the record. And when you have jurisdictions that simply say diversity is its own goal, the court said today clearly that's something for any community to be able to decide how they would like to implement diversity.
Eugene,
no constitutional principles.
There is a context here. There's a context here in Michigan. For well over a decade now, administrators at the University of Michigan, where I went to school, by the way, have been trying their best to keep a policy of action in order to have. They believe that's important. They believe that's important not only for the education of all students. They believe it makes the University of Michigan campus in Ann Arbor and the other campuses a better environment. So first Lee Bollinger, who's now president of Columbia, was president of the University of Michigan. He's the plaintiff in one of the Supreme Court lawsuits over this issue. Mary Sue Coleman, who then became president of the University of Michigan, has followed it up. This is something the university wants to be able to do and believes is justified, not only on the grounds of what it means for society, but on the grounds of what it means for their campus and what it means for that school.
And I'm wondering what message...
And my point is...
Quickly, Horace.
My point is just simply, the court said that that kind of determination is open for all of society to participate, and it doesn't implicate any constitutional concern.
Well, Horace, let me ask you what message you think is being sent by the majority on this court. First, you had in the case of eviscerating the Voting Rights Act, the statement from Justice Roberts that essentially, hey, you know, discrimination is over. That's the past. We don't have to worry about that anymore. And this notion from Justice Scalia of racial entitlements. When you combine that with this judgment, which essentially says the majority can decide whether or not the minority in its midst can have the protection of affirmative action law, what is the message being sent, particularly to African Americans, to other minorities, by this court?
Okay. That's been the problem all along, and that's the reason why so many of these cases are losing. Instead of following the appropriate predicates, bringing forward prosecutions for voting rights discrimination, bringing forth plaintiffs who say, I wasn't allowed in, we have created the chimera of the institutional racism. No federal court has ever accepted that. Left, right, middle.
Okay, we're out of time. I want to let Eugene
it.
Robinson in. Is the idea of racial discrimination a chimera or a chimera, depending on how you pronounce it?
I don't think it's a chimera or a chimera, Joy. You know, it's very real. And look, find me the academic study. Find me the evidence that racism is gone, that it's gone poof and no longer plays a factor in American life. Well, I challenge you. I can't find it. I can find lots of evidence to the contrary. And as long as we can find lots of evidence to the contrary, I believe these kinds of remedies are needed, and I think that the federal government has an interest in making sure that they are applied and they are used to the extent they ought to be used throughout the country.
All right. Well, Eugene Robinson, Chief Justice John Roberts says it's over, and it's over because he says it's over. So, thank goodness, racism is done. Horace Cooper, Eugene Robinson.
I didn't get the memo.
Thank you very much for being here, both of you. All right.